Daniel was sitting in the back of a patrol car in Scottsdale when the arresting officer picked up his phone. When the cops asked to search your phone in Arizona, most people freeze. Daniel froze. He didn't know his rights, didn't know what to say, and had no idea that one word would determine whether everything on that device became evidence. What most people don't realize is that the Supreme Court has given your phone more legal protection than almost anything else you own. But there's a critical exception that catches people off guard and has nothing to do with whether you've done anything wrong. Why your phone is different from everything else. In 2014, the Supreme Court decided a case called Riley v. California that changed everything about how police interact with your phone. Before Riley, officers could search most items on your person during an arrest without a warrant. Your wallet, your pockets, your bag. The logic was officer safety and evidence preservation. The court looked at the smartphone and said, no, these are different. A phone contains your entire life, your emails, your photos, your medical records, your financial information, your location history, every text that you ever sent. Chief Justice Roberts wrote that a phone search is more intrusive than rummaging through your home because at least at your home, you have the option of keeping certain things there. Your phone holds it all. The ruling was unanimous and clear. Police generally need a warrant to search a cell phone, even during lawful arrests. That's the baseline, and it applies in Arizona just like every other state. The exact words to use if an officer asks to look at your phone, hands it to you and says, unlock it for me, or says something like, I just want to check something real quick. Here's what you say. I do not consent to a search of my phone. That's the sentence. Memorize it. Say it calmly, say it clearly, and then stop talking. You don't need to explain why. You don't need to justify it. You don't need to say, I have nothing to hide. But because the moment you start qualifying your refusal, you create ambiguity. And ambiguity is not your friend in a courtroom. If they press you, repeat it. I do not consent to the search of my phone. In my experience handling these cases, the people who state their position once, clearly, and then go quiet are the ones whose rights hold up in court. Passcodes, fingerprints, and Face ID. This is where it gets complicated, and it's part of the most people have never thought about. There's an active legal debate across the country about whether the police can compel you to unlock your phone with your fingerprint or face. The Fifth Amendment protects you from being forced to provide testimonial evidence against yourself. A passcode is something you know, and courts have generally treated requiring you to reveal it as compelling testimony, which means it's protected. But your fingerprint is something you are, and courts are split on whether pressing your fingerprint to a sensor is testimonial or merely physical, like providing a DNA sample or standing in a lineup. Some courts have allowed compelled biometric unlocks. Others have blocked them. In practical terms, the safest approach is to use a passcode rather than biometrics, or to disable biometrics before an encounter if you have time. On most phones, pressing the power button 5 times rapidly disables Face ID and fingerprint unlock, requiring the password instead. That one step changes the legal equation entirely. Here's why this matters so much. If a court in your jurisdiction decides that compelled fingerprint unlock is lawful and your phone is set to biometrics only, you may have no legal basis to refuse. But if your phone requires a password, the Fifth Amendment analysis tilts heavily in your favor. The technology you choose today determines the legal protection you have tomorrow. If an officer demands your passcode, your answer remains the same. I'm not going to provide that without speaking to an attorney first. You're invoking your Fifth Amendment right. That invocation cannot be used against you. We cover what those rights actually mean and what they don't mean in the Miranda video on this channel. When police can search your phone without your consent. Despite the strong protections from Riley, there are situations where officers can access your phone. The most common is with a warrant. If officers have probable cause and a judge signs a warrant specifically authorizing a search of your phone, they can search it. The warrant must specify what they're looking for and which device. A warrant for your laptop doesn't cover your phone. The second is exigent circumstances. If police genuinely believe the phone contains information about an imminent threat to life, a kidnapping in progress, a bomb threat, they may argue that waiting for a warrant would cause irreparable harm. This is a narrow exception and gets litigated heavily when it's invoked. The third is consent. If you say yes, everything Riley established goes out the window. That's why the words you use matter so much. 1. Go ahead erases the strongest digital privacy protection the Supreme Court has ever created. Whether police approach you during a traffic stop or show up at your door, which we cover in another video, the phone rule stays the same. They need a warrant. What about during a traffic stop? If you're pulled over and an officer asks to see your phone, the same rules apply. We cover the full breakdown of your rights during a traffic stop in another video, but the phone's specific rule is straightforward. They need a warrant. Being pulled over does not give officers automatic access to your device. Where people get tripped up is when the officer says something like, I need to check if you are texting. Arizona Distracting Driving Law, ARS Section 28914, makes it legal to use a handheld phone while driving, but an officer's suspicion that you were texting does not authorize him to scroll through your messages. They can testify about what they observed, your driving behavior, whether they saw you looking down at your phone, but the phone itself requires a warrant. Don't hand your phone over voluntarily. If you need to show your license or insurance from an app, hold the phone yourself and display the screen. Don't hand the device to the officer. The moment it leaves your hand, things can escalate in ways that are hard to undo. Has an officer ever asked to look through your phone? What did you say? I want to hear your story in the comments. If they already searched your phone without your consent and without a warrant, that doesn't mean the evidence sticks. This is where suppression motions come in. Under the exclusionary rule, evidence obtained in violation of your constitutional rights can be suppressed, meaning the prosecution cannot use it at trial. If your attorney can show the search was conducted without a warrant, without valid consent, and without a qualifying exception, the contents of that phone may be thrown out entirely. And in many cases, if the phone evidence was the foundation of the prosecution's case, losing it means losing the case. The key is that you clearly refuse consent. If there's any ambiguity, if the officer testifies that you nodded or shrugged, said, I guess, that becomes a contested issue. I do not consent to a search of my phone. Leaves no room for interpretation. That's why I keep coming back to those exact words. One more thing. If officers obtain a warrant and search your phone, your attorney can still challenge the warrant itself. Was the probable cause sufficient? Was the affidavit accurate? Was the scope of the warrant too broad? A warrant that authorizes a search for your text messages doesn't give officers the right to browse through your phone library. Scope challenges are among the most effective motions in digital evidence cases. Your phone is your life in your pocket. The law recognizes that, but the protection only works if you invoke it. Know the words, say them clearly, and let your attorney handle the rest. If you've been pulled over, you're wondering what else officers can and can't do during a traffic stop beyond the phone issue, I break down the full playbook in the video right here. And if you need to talk to someone about a phone search that already happened, our contact information is in the description.